Thank you for joining us at our webinar called 8 Critical Mistakes. My name is Tammy Sawansky. I'm one of the paralegals here at Bott Associates, Ltd. I would like to now introduce you to speaker Marites Bott. Many of you already know her. Marites has been an attorney for over 24 years. She focuses her practice on estate planning, probate, and trust administration. She has been a proud member of the American Academy of Estate Planning Attorneys since 2003, a national organization dedicated to promoting excellence in estate planning. Without further ado, please welcome Marites Bott.
Thank you, Tammy. Appreciate the introduction. I think one of the first things, well, first of all, I want to say welcome to everyone, but I also want to remind everyone that this is somewhat of an interactive webinar. We are going to ask you to answer some polls, and we're actually going to do the very first poll right now. So we're going to go ahead and get started with just a poll, and then just click your answer, and then we'll see what the results are.
Okay, Marites, it looks like the question was, why are you attending the webinar today? 33% of you said you wanted to find out if there were any issues addressing to your estate plan. 0% of you said you want to learn more about estate planning for the first time. And 67% of you said just wanted to educate myself.
Awesome. Wonderful. So I'm glad that you do want to educate yourself and that you want to hear a little bit about the estate planning mistakes, right? Challenges that we have. So first of all, I want to welcome you back. What does that mean? Because we haven't seen some of you in a while. You might have seen our seminar 10 years ago, 12 years ago, did your estate plan then, and haven't come back since. So we do want to welcome you back. And so these are some of the reasons that people need estate planning in general: death and taxes, because they're worried about nursing home expenses. Sometimes families are torn apart, so they're worried about that. And sometimes it's your plan may not work. But first, I have a confession. What does that confession mean? Our mission is always in our firm to make sure that you have an estate plan that works, right? That's our mission. Our mission is for you to have peace of mind, that you don't have that 2 a.m. wake up and worried about something, because we want to make sure you feel good about your estate, that it's going to go to the right people at the right time without any, complications. And so initially you work with us, we go ahead and we prepare that document, and then sometimes after you've signed those documents, you have things that just we needed to make some changes, right? You have to have some changes because your circumstances have changed or other things have changed. And we completed the work based on your situation at that time. When you finish that up, though, a few of you ask for guidance through that time period, but sometimes you don't come back and say hello to us and check in and see if there's any changes on your estate plan. And what does that mean? Well, it could have been a mistake. So over the years, what we found out that if you don't see us consistently, so we usually say every 3 years, let's have a conversation either by Zoom or on the phone. Let's see if there's any major changes in your family, in the law, in the circumstances, and make sure your estate plan is not jeopardized. You work too hard for the assets you have, and we worked really hard together to get the estate plan set up. And sometimes we find out about those mistakes when it's a little bit too late. We only find out about it when there's an issue, whether it's incapacity, person has been incapacitated, or certainly when a family member has died. What you don't know can possibly hurt you, your family, your estate, and we don't want that to happen. And so the work is really important to get it done right, because tragic and expensive work can be really upsetting to a lot of people. So sometimes assets can go to probate, and you didn't intend to do that. Remember that seminar you might have attended years back? Our goal is to avoid probate. Sometimes the nursing home costs can just wipe out your entire estate. Sometimes it's a guardianship that we have to go through, a conservatorship. Poor investments might have destroyed your whole kind of asset base. Sometimes people just fight over things. Oh, I can't even tell you. Money and family, relationship always tends to end into some kind of friction, and that's unfortunate. Sometimes tax benefits are lost, and then chaos can erupt if the family members have no idea what to do, and of course 100 other problems. So we see this all the time. This is what we do day in, day out. We want to prevent all of that for you. So as a firm, we vowed to make sure that doesn't happen to our clients, at least most of them. I know we can't force you to come in. I can't force you to update your estate plan, but we're going to do our best to inform people about what to do. So in a nutshell, that's what we're here for today. We're going to talk about the 8 critical mistakes so that you don't make them, so that we address your estate plan again and then really figure out what needs to be done. And we've all lived through quite a bit in the last year and a half, right? It's quite a bit of, uncertainty, worry, people losing their jobs, people worried about their kids, people worried about older parents that might have, contracted the virus, whatever it might be. This was the wake-up call for everyone. It makes this type of planning even more urgent, more important. And instead of putting it on the back burner, people were calling us. So we have been busy during this time. We've helped a lot of families, and I always want to make sure our families that we've worked with, 10 years ago, 12 years ago, are also updating their plan. So what do we promise to cover? Well, we're going to talk about those details of the 8 critical mistakes. We're going to give you an opportunity to schedule an audit, kind of figure out if any of these mistakes are going to happen in your estate plan right now, and we can fix it now. And then, of course, we'll answer any questions that you might have. So how do you ask questions in a webinar, right? If you've never been on a webinar like this, you do go on the chat box or question box, I think there's 2 there, that you can write in or type in a question. And what will happen is Tammy will read them out to me, and I'll answer your questions throughout the seminar or webinar. So feel free to do so at any time, and we'll go ahead and address them as soon as we can. Okay? So let's review. What are the 8 critical mistakes? How clients routinely destroy their estate plan. Here they are, and they were in the invite, so you kind of have been prepped for it. But number 1 is not keeping up with the laws. Number 2, not updating for family changes. Number 3, not planning for nursing home costs. That is certainly something that we don't really think about right away, right? And now that people are getting older and living longer, it's certainly an issue in people's minds. Funding for your trust may not have been maintained or even updated. Assets that are purchased may bypass the trust all, 100%. So we don't want that. Plan assets, your assets might not be suitable for your family goals. What does that mean? Your investments, your 401k, your IRA, your mutual funds, are they the right investments for you? So we should talk about that. Number 7, family is unaware of the plan itself and their duties. And number 8, the plan does not reflect your values or life lessons. Those are really key. So let's start with number 1. Okay, number 1 is there's lots of laws that change. Surprise, surprise, the government wants to keep changing it, right? And they are changing all the time, and we're not always paying attention, right? You live your lives, and you're too busy to think about what laws are being passed. But here's a nice little quick summary of some of the major estate tax changes. This is just one law, estate taxes. And you can see from 2016 all the way down to just last year, lots of changes, lots of things that have happened. So the one I'm going to kind of focus on, of course, is the one from last year. It's called the Secure Act. Probably some of you have heard about it and thought about it, and we did have some communications last year about it. But the key thing about the Secure Act when it comes to estate planning for us is that there was the rule before last year was that you can take your IRA, give it to your grandchild, and that grandchild can actually stretch that IRA and defer the income tax that needs to get paid until that grandchild turns 70 and a half or until retirement age. And that's a huge time frame, right? So if the grandchild receives it at age 25, 25 to age 70 is a big time frame that they don't even have to pay tax on until that time frame. That was a big deal because last year, Secure Act says, the government says, I want to get paid now, right? They want the money sooner rather than later. And so what they chose was every inherited IRA, there are a few exceptions, but every IRA that's inherited by, say, a grandchild, has to pay the tax within 10 years of receipt. Okay, so that's a big difference. It's no longer that long in your lifetime thing, it's more of a 10-year thing. Also, the required minimum distribution has changed. So I keep saying 70 and a half because I'm used to that number. It's actually 72 as of last year. So if you are nearing that age, you are going to be required to take money out of your retirement accounts every single year. And you can still contribute to your IRA over the age of 70 and a half. So that's another thing that they are realizing, that people still want to contribute, even though they might, either they might have been past that age already. There's also a bunch of laws that have helped small business owners, right? There's a lot of tax credits. There's annuities that can be easily added to a 401k now. And then there's also early withdrawals of $5,000 allowed for birth or adoption. So those are just key changes. The act itself is this thick, right? It's pretty long, but these are the key changes that I think would affect estate planning. Some of the solutions for that 10-year requirement include these three things. And so if you are charitably inclined, we can certainly talk about the option of a charitable remainder trust. Or you can Rothing your IRA. If you don't know what that means, it just means that you're going to take your traditional IRA and convert it into a Roth IRA. But what that means is you're going to pay, the tax in your lifetime right now. And once you convert it to a Roth, your child or grandchild now has a tax-free retirement account. So they could take that and not have to pay tax anymore, which is nice. And then, of course, as they invest it, they will, decide as far as getting, they'll get taxed on their tax level. But at least they will never be taxed on the actual distribution when you got it. You get it as an inheritance, okay? Last option is a life insurance policy. That is something that definitely we need to talk about more because there's a lot of factors, but you can certainly get a life insurance policy to kind of replace the tax that the inheritor is going to have to pay. So that's another option that we can talk about. So these are very specific to your situation. I highly recommend, if this is something that's kind of worrying you, do you need to come in for this particular act and this particular law? It depends, right? So if you have an IRA that's significant in value, which many clients do have that, then definitely come in, let's talk about this. If you've named someone other than your spouse as your primary beneficiary, and you're concerned about them getting this money in the 10 years, right? So maybe it's a child that has a drinking problem, and you don't want this child to get this money immediately within those 10 years even, then let's talk about that. Let's figure out what's the best way. And then last, if your trust is your primary beneficiary and you're worried about the beneficiaries that are getting it in 10 years, definitely come in. So these are examples of why people who might need to come in. There's also state inheritance and federal estate taxes, and the exemptions have gone up, quite a bit. Right now, the federal exemption is $11.7 million per person, and that's a lot of money. But it can go down quite a bit based on whatever the new laws that they decide. So we'll figure out what that'll be. The Illinois state inheritance exemption is $4 million per person. So that changes all the time in terms of I don't have the crystal ball. I don't know when it's ever going to go down or up. So we just kind of sit and wait and see what they tell us. But as far as income tax planning, there's always lots of rules too. There's lots of ways to minimize income tax under this 2017 Act. So if you are interested in hearing more about things to do to reduce income taxation, that is another way to come in and say, what can I do? I make too much money. How do I pay less in taxes? Another area of law that can change pretty much all the time is the statutory healthcare powers of attorney and financial powers of attorney. So the one that we use right now, I think, is the most recent one that's about, say, 2-3 years old. It's not that old. If you have one that's from 10 years ago, 20 years ago, it's valid, but it may not be valid. It really depends on the institution or hospital that's going to look at it. And I tell people, let's update it even 5 to 7 years. That way, that is going to be the most recent, and it can be used for your benefit if you're disabled and somebody can take care of those decisions. Another area of law that's changed quite a bit is remarriage protection. So when you did your estate plan, you might not have even thought about this issue, right? And it just means that if your surviving spouse gets remarried, do we want to put some provisions that protects the kids from that remarriage? Because most people are like, no, we saved money. We want it to go down to our children, not to the new person and that new person's family after, the first spouse dies, right? So there's ways to put remarriage provisions to protect that, okay? The statistic is by 25 months after a first spouse has died, so that's only 2 years, 61% of men remarry and 19% of women remarry. So when people tell me, oh, my husband will never remarry, he loves me way too much, I give them that statistic and they're kind of shocked and they're kind of like, well, if that happens, then I'm going to make sure that your woman will not get this money, right? So we put in protections in there. Another area of law that changes quite a bit is Medicaid planning. People are worried about that because long-term care costs are so expensive. And we definitely want to be able to protect the beneficiaries, right? And make sure that they know, how they're going to be able to get this and how we can protect the assets. There's another, section that we're going to talk a little bit more about Medicaid. But we're now going to move on to mistake number 2. The estate plan is not updated to reflect family changes. Right? When you see me, maybe it's 15 years ago, you have your kids, maybe they're teenagers, and everything's hunky-dory, everything's fine. 15 years later, your children are grown, they've now gotten married, they've had kids, and then perhaps your children aren't really the best option to act as trustee. Maybe one of your kids has an addiction. Maybe one of your kids is going through a divorce and you're worried about that money going to an ex-son-in-law or ex-daughter-in-law. So the person that is going to handle your trust, such an important role. You want it to be the right person. And so if your life has changed, the people in there have changed, let's review it, because the last thing I want is for some alcoholic to be able handling your funds and figuring out, gee, I wonder who gets this money, right? We don't know if that money will be given to the right people according to your estate plan. Same thing with decisions if you're ever disabled. So remember, a power of attorney only acts if you're alive and you're incapacitated, okay? What that means is if this person, so if I'm incapacitated, then my husband would make decisions for me. But if he's not around, then the next person in line has to really step up, pay my bills, access my bank accounts, and then talk to all the doctors and figure out what is going to happen with Meritess. Do we need to have an operation? Do we need to have some medication? All sorts of things that the doctor is going to ask about her care. So is the person that you've chosen the right people? Right? Maybe, again, it's a child that has an addiction. Maybe it's a child that's not in the same city. That's another thing. People move everywhere. We're such a, kind of a global society. We all move wherever our job is, or in light of COVID, people just move to the islands so that they could just do their job somewhere else. So people move everywhere. And if your son or daughter is not in the same city that you've chosen as the medical power of attorney, you might want to choose the other child who happens to be, 10 miles away. So definitely something to think about. Do you have new beneficiaries? Let's come in and talk about your grandchildren. Let's see those baby pictures. Let's see who we want to give money to. So I see more and more often that grandparents actually want to leave some stuff to their grandchildren and not cut out the children automatically, but also just say, you know what, I want my grandkids to remember me. So once you have more grandchildren, or you want to put a grandchildren's education trust together, we can do that. We can help you with that. And then if you don't have children, perhaps you put in 5 beneficiaries, but 4 of which you don't talk to anymore. Your relationship has fallen out, right? And you forgot that they were in your will or in your trust. Let's change that. We don't want someone random to get your estate. Let's make sure it's the right people. I always tell people I'd rather give it to the charity of your choice rather than random people that didn't care about you while you're alive. So I'd rather have something written down that is your decision. The other type of beneficiary that I worry about is special needs, right? These are children or adults that may have, a special needs that they're getting some type of Medicaid and SSDI or SSI payments. The minute you give them money as an inheritance, they're going to lose their benefits like that, like they have no more benefits. So we don't want them to do that. So we want to make sure we create a special needs trust for them. So what I say, they get their cake and they eat it too. So it means they get to have the benefits that the government provides them, but then they also get the access to the money that you've given to them as an inheritance. Marriages and divorces. They say that 53% of marriages end in divorce. I think I see a lot more people who don't even get married in the first place because of this statistic. So maybe a child or grandchild is going through a divorce. Maybe you've been going through a divorce, whatever it is. Let's just make sure that the money is going to the right people, okay, based on this situation. Perhaps it's just a change in your assets. So many people, they change jobs. So now they have new IRAs or 401ks, or they move to a new state even, and now they have a new house. Whatever it is, we want to know exactly what's in your kind of asset summary so that we know whether the estate is fully funded or it's all in the trust. We just want to make sure it's all done properly so it doesn't go to the wrong people once again. So now we're going to go to mistake number 3. This is a really big one. People are worried about nursing home costs. And what is your plan for nursing home costs? Because it's quite expensive, right? The average in Illinois doesn't even touch the surface, because even though $82,000 a year is a lot of money, here in our area, northwest suburbs of the Chicagoland area, it's about $10,000 a month. So that's $120,000 a year. That's a lot of money. And you can imagine all of those hard-earned assets that you have can dwindle down really fast. And how long would it take for your estate to be cleaned out? It doesn't take much. $120,000 a year, if you've held on or at least saved up, say, $400,000, that's not much, right? Under 4 years. And what are long-term care expenses? Why do I need it, right? What do you mean I'm going to need it? It's what if you have a stroke? What if you have dementia or Alzheimer's? Who's going to take care of you? And many times people say, my kids will take care of me. What do you mean? I raised them. They should be taking care of me. Well, not always. Kids don't always have the time or the money to stay home and take care of you. So how are ways that people pay for long-term care? Pay for it by their own money. They pay for it, with long-term care if they have it, insurance. Apply for Medicaid, Medicare. Most people think, I'm going to just be fine. Medicare takes care of me. Not quite. It's a very limited amount through Medicare, and Medicaid is difficult to get on. Last is just if you are a veteran, there are some benefits through the VA. So we have to start planning for our long-term care needs because we don't want to risk destroying our estate, and we have to plan for that, right? Because we all know that our health care, we don't have a crystal ball. And this is the roulette of all the different things that are quite debilitating, and this is probably a small list. And if you're unlucky, right, you can end up with Alzheimer's. And how does it work? Well, you have Alzheimer's, and a lot of times it's a long process where it seems like you just forget a lot, but at some point your family's going to realize, well, mom or dad cannot be home by themselves, and I can't be there all the time, so how are we going to take care of them? And so they just automatically think, well, the government will take care of them. Not quite, right? Because Medicaid is usually the first thing that people think of, that I thought the state takes care of this. Not quite. So here's how Medicaid works. The basic requirements sounds pretty basic, right? 65 or older, you're blind or disabled, and then you have to have minimum income and minimum assets. That's where they get you, and that's where it is. So what does that mean? Well, you take all your assets and we kind of figure out what is countable and non-countable. And this is for purposes of qualifying for Medicaid. Some things are countable. So you can see here, investments, checking accounts, savings accounts, those are all things that are countable as part of your estate for purposes of qualifying for Medicaid. If you're single, you see all this list, you can only have $2,000 of this list. That's it. Not much. Non-countable assets, well, there's a few things you can keep. If you end up keeping your home, you're allowed to keep the home. However, in Illinois, it's a recoverable asset. So what does that mean? It means the government, Illinois, can actually file a lien on your property when you're gone so that they can get paid back for the care that you were given. So it's recoverable. So I say home in air quotes because you just don't know if the government will go ahead and file that lien. You can have household goods, you can have burial and funeral, you can have one automobile, and then all of these things. But the goal is always to move assets from countable to non-countable, right? And so that's really impossible for most clients. They can't figure it out. And most clients are kind of like, well, I have an easy solution. I'll just give it away. So I'll give it to this person and this person and this person. But once you start giving it away, you're going to be denied from Medicaid. Why is that? Well, there's this such thing as a 60-month look-back period. And they're going to ask you for statements for the last 5 years and look for things that are big transfers. So if you gave your daughter $100,000 in this year and then your son another $100,000, then that denied stamp will happen for your Medicaid application. So you can't do that. It's, everyone would do that if it's really obvious and available. And then once you give it to your kids, then basically anything that happens to them will be your assets at risk. Because if they get divorced, if they have a lawsuit, then basically your asset that you just gave to them is part of that lawsuit. So I always worry about just gifting freely to your kids. There's other ways that are much better options. Living trusts, if you have a living trust, is not designed to qualify for Medicaid. Just remember that there's a lot of benefits when it comes to a living trust. There's a whole host of them. We want to avoid probate. We want to make sure your kids get the money or the beneficiaries get the money in a way that is the right way, and all sorts of things, right? So that's the advantages of just a typical living trust. It's not designed for the nursing home part. So don't despair. So what we want to do is basically create a better bucket So what we always try to offer to people is a wealth preservation trust, a Medicaid trust. And what does that mean? We take some of your assets from your regular trust and put it into the Medicaid trust. Don't do it yourself. It's not easy to navigate through these laws. And so we're going to do a couple polls here. We're going to take a Medicaid quiz. So look at this couple. We've got Bill and Mary. They have about $700,000 of assets. They have a home. They have all these different things. They have income. And Mary is the one that needs to go into a nursing home because of her dementia. Okay? And we want to make sure that, she gets on Medicaid and that she can go into a nursing home, and then Bill would have to, would be living in the community. So we're going to go ahead and launch poll number 2? 3. Okay, sorry. So go ahead and launch that if you can, Tammy. So will Mary qualify for Medicaid?
Okay, so 20% say yes, 80% say no.
And that's exactly what the typical response is, but you would be surprised. They are approved. And I won't go into all the details of why they're approved, but it's dependent on the type of assets that you have, and then whether, and income, okay? So I'm going to show you couple number 2, Ralph and Ruth. Look at them. They have only $100,000 of assets, so lower assets, and you can see the different things that they have, monthly income. And now, can Ruth qualify for Medicaid? Let's launch that poll.
Okay, so 0% say yes, 100% say no.
Ah, interesting. So all of you were right. They were denied. So they're denied, and look at the comparison. So it doesn't matter necessarily the size of your assets. It's what your assets comprise of. And it also depends on your income. And again, I'm not going to go into detail of why one was denied, one was not. It's something that we should definitely discuss in a one-on-one meeting. All right. Mistake number 4, funding is not maintained or updated. What does that mean? Well, it means that when you first start and create your trust, we put stuff in the box, right? You see there's a box there. We create it and we fill the box. But as time passes, people pull things out of the box. People put things in the box. Sometimes it's just outside, not in the actual box. And that's one of those things where sometimes you just don't remember. Even though I tell people while they're signing their documents, remember that you always have a trust, that you want all your assets to be owned by your trust. But sometimes you forget, and that's okay. Because the magic is keep your assets in trust. Make sure that they're either titled in the trust or that some beneficiary is the trust in your estate or your assets. So you have all these different types of assets. As long as everything is titled in trust, perfect. Then we don't have to go through probate. But I can't tell you, time and time again, people have come to us, person has died, we did a great job maintaining and keeping everything in trust, but they had that one little account, the savings account that they opened kind of either recently or maybe 20 years ago. They just forgot about it. And now we have to go to probate just for that. So we don't want that to happen to you. Lack of proper funding is a common mistake, and we don't want that to happen to you. Number 5, assets that completely bypass your estate plan. You might be thinking, what? That actually happens? Well, there's certain types of assets. It just depends. So for instance, you have an asset that might be joint tenant with right of survivorship, right? And maybe you put your son on your house and you said, okay, it's me and my son on the house. When I die, my son gets 100% of my house. right? It automatically goes to him. It bypasses my trust, even though my trust says everything's equal shares to all three of my kids. Okay, so joint tenancy, we forget that that isn't automatic and we can't really undo it if it's already in the document and the person has died already. The other type of asset that has beneficiaries is life insurance, right? When you put people on there, if you had put down your ex-wife on there long ago and never changed it, well, guess what? The state of Illinois says it goes to your ex-wife. Even if you've been divorced for 20 years, it doesn't matter. So those are so key when you're getting divorced or when your children are grown and maybe you don't want to give it to your kids, you want to give it to your grandkids or anyone, okay? I always recommend putting your trust as the beneficiary. It's much easier. You just know exactly who it's going to. Same thing with annuities. You have beneficiaries there. Make sure it's the right people, or you have the trust on there, and then the trust is the one that gets updated and will do that for you. Retirement accounts. Same thing. It's very easy to check the box and just say it's going to my son and daughter. But especially for young families, when you put in little Johnny and little Susie on as beneficiaries and they're 5 and 3 years old, if you die unexpectedly, guess what? That money is available to them at age 18. It doesn't even matter that you wanted it to go at 25 or 30 in your trust. If the designated beneficiary is your kids directly, they have to follow that, okay? So let's summarize the mess you have on your hands. So this $1.2 million estate, for example, all of those assets listed there were given to people based on the beneficiary or based on joint tenancy. And how much of the estate is actually controlled by your estate plan? Probably a little bit, just like your checking, your savings, and car. Everything else had that. So that might not have been your wish, your objectives. So let's review that. Let's make sure it's exactly how you want it, because I wouldn't want this mismatch to happen for you. Number six mistake. Assets in the plan are unsuitable for the family goals. Many people come to our estate or our firm and show us their assets, and they give us stacks of statements, and it might be 20 different banks or institutions, and they just have a hodgepodge of investments. And I asked them, well, do you have someone that guides you? Do you know that you could consolidate? Do you like having all of these, papers, especially during tax time? And really, they don't. It's just kind of accumulated that way. They don't even know how they're invested. Are they really invested in their fashion and with the risk tolerance that they're willing to take? And many times they don't. They don't know. So we're here to help you with that. We can help guide you with that situation. Another thing that I worry about, especially as clients are getting older, are scams. Right? We've all heard of Bernie Madoff. Yes, sadly, he's already passed, but he is the king of the scams. But he's one of thousands of scammers out there that you will find that'll just be like, hey, they'll call you on the phone. Hey, yeah, if you put in $5,000, I can make it $100,000 within 2 weeks, whatever the scam is. And sadly, I've seen a lot of our clients, they have their sad look on their face like, I'm really embarrassed. I'm really ashamed that I fell for this scam. I lost $200,000 because I fell for it, whatever that was. And that's what I don't want to happen to you. And so if you are at all contemplating some major investment, please call us. Please ask us. We have the expertise to at least help and guide you so that you don't lose out. And we want to make sure your investments are suitable for you, that they perform. Because I'm really proud of our estate plans, making sure your assets are protected from death or disability. But if there's no assets to protect, then there's no point of having an estate plan. So I want to make sure your assets actually grow and is there for your family and your beneficiaries or your favorite charities. It's got to perform. And if that's something that you're concerned about at all, please come see us. Please come see us. We're here to help you. Number 7, we have 2 more. Number 7 is the family is unaware of your plan or their duties. So what is that? Well, sometimes people don't even tell their kids that they even have a plan in itself, right? No one knows. So it's just sitting there waiting. And they may find it, and then they find our name, and we have that discussion. But I think it's just more important for them to know that my documents are in the closet, in the drawer, look underneath this, wherever it is. You don't have to give them the details of the plan, but make them aware. Make them aware of what the plan entails. Or I even tell people, give them my business card. That might be an easier way, because we want to be kind of their first kind of point of contact if there's an emergency. Because guess what? Especially COVID, that's kind of made us aware of this possibility. If you're rushed to the hospital, does your family even know where your medical directives are? Do we even know that there was a healthcare power of attorney in place, and how can we get a hold of that healthcare power of attorney agent? So when you're rushed to the hospital, just think through what would happen. I have people who put them on their refrigerator or their door, like they attach it everywhere. We also have a way that we offer to our clients. It's a company called DocuBank, and you keep that card. You have a card in your wallet that if it's ever an emergency, the nurse can actually get access to your healthcare power of attorney immediately, within minutes, either online, fax, whatever, the way to get it. And so I'm a big fan of that, because just when I was having my third child, she's 12 years old now, I'm having contractions and pain, and I'm sitting on the hospital bed, and the nurse is like, ma'am, can I have your healthcare power of attorney? And I'm like, really? So my husband pulled out the card, she went and got it, and she came back in a few minutes, and she was actually amazed that the healthcare power of attorney was instantly given to her. It works. And so I'm like very big fan. If you don't have that, please come see us and we can help you. So if you're incapacitated, somebody has to pay your bills, right? If you're incapacitated, you're alive, you have a stroke, you can't talk, you can't make decisions, somebody still has to keep that financial life going. It might be the same as your successor trustee. It's typically the same person. Do they know about their duties? So it's definitely important to get them to know, understand that. And then certainly, so that's incapacity, you're still alive. And certainly when you pass, you want your family to know what to do next. So it's already a very emotional time. You're already putting your family, in a situation they're grieving, they're trying to figure things out. Do you really want them to have to figure out what's the funeral arrangement? What would mom want? What is it? And that's their job. But if you can make it easier for them, maybe prepay or write down all your instructions. I mean, I have people who literally know exactly what the wedding or the funeral mass is going to be like. Here's the songs I want, here's the readings. Whatever detail you want, you can do that. Another thing is, what if you had planned on unequal distributions to your kids? So Johnny got 65%, Susie got 35%. And Susie opens up the will and is like, what the heck? I'm the one who was standing by mom all day, every day when she was going through her illness, and you're getting 65%? That happens often. So I suggest that if there is that situation where you are doing that, you can do 2 things. 1, have a family meeting and explain your situation. Or if you don't want to do that, because that takes a lot of guts, is write down your wishes. Write down in your own words why you chose to give 65% to Johnny and 35% to Susie. Because there might have been some valid reasons. Maybe Susie got a loan from you that she never paid back. Maybe she went to Harvard and, Johnny went to community college and you wanted to even that out. Whatever it was, write it down so that maybe Johnny and Susie can still see each other for Thanksgiving. That's the goal. Make them have a decent relationship after you're gone. Sometimes there's big problems when it comes to even personal items. I wanted that bowl. I wanted that ring, whatever it might be. So write it down. Make sure you have that written down. Arrange for a meeting maybe, right? We do that all the time. We have a family meeting, we bring everybody around, and that way they can know exactly what's your estate plan's like, who's going to be in charge. Obviously, you can still change your mind, but at least they know who we are and they know we're a resource. But then they also have an idea that this is all has happened, okay? Last mistake, number 8, is the plan does not reflect family values or life lessons. So what does that mean, right? Usually, traditional planning just says, let's avoid probate, let's reduce taxes, let's do all this that deals with just the money itself. But you know what? The money is just part of your estate. Let's talk about your family, your friends. Like, what do they mean to you? What kind of values do you want them to have? Because we believe wealth is really a whole bunch of things. So if you are incredibly passionate about your charities, let's put it down that they have to come together and decide on which charities, like maybe you're into pets, which pet charities they have to give to. Or if you want the kids to go to school, let's put it down that you got to go to college in order to get a degree, or else you're not getting money from the estate. Whatever you feel is important, your legacy is way more than the money. Way more. Okay? It's also about your relationships. It's also about your accomplishments, your heritage, and really everything that you've kind of created, your life. And you could have a family tree and it's just like your name is put in there. But what if you wrote down some things, right? We actually have this book. If you're interested in getting one, feel free to call us. And it's a great book to kind of write down your legacy, like what was your childhood like? What was your favorite book as a kid? Where did you live in all those different places? Maybe you moved around a lot. Another option I always say is a great option, and I wish I could do this more with every one of my clients, is let's record. Have someone record an interview about you. Believe me, each of your kids or family members will cherish that video more than, the IRA that you left them, right? It's important that they see you and that you can share your own story. So let's bring it all together, okay? Now that we've gone through all the 8 mistakes, I want to just share the opportunity that each of you can have. We can do an audit of your estate plan to figure out, do we have any changes? So one of the results that can happen is maybe there's no changes at all, and that's perfectly fine. I would love to have that time with you just to get back in touch with you, reconnect, hear all about all the good things that's happening in your life, and no changes, nothing at all. That's fine. Another option is maybe we need to transfer things because of the funding, right? Maybe a few things weren't in the trust, so let's do that. Another particular result could be an amendment to your trust, right? Or even what is called a restatement, redoing the whole thing. It really depends on lots of different scenarios. So it's not something I can do in general. It's really a one-on-one conversation. And the Medicaid planning, if that's something that's of interest to you, we're going to definitely touch on it and make sure that we have that in your estate plan. And lastly is, if this worries you about being scammed or whether your investments are properly allocated and in the right place, come see us. Let's take a look at that. Let's make sure your money is actually working for you, not against you. That's really important. And so what to expect is just spending a little time with me. It could be in person. It could also be by Zoom, because we are still doing Zoom meetings. And we would have, just a 30 to 45-minute discussion about all these mistakes and see if we have to do that, right? And that is it. So what is the next step? So I think we'll do a last poll, I believe, and then we'll talk about the next step.
Okay, results are in. The question was, since I last updated my estate plan, 40% of you have said there has been a marriage or divorce in my family. 20% of you said that there have been significant changes in my financial circumstances. 0% says that they are or have received a sizable inheritance, and 40% said, I need to plan to ensure nursing home costs don't eat up my entire estate. So a little bit of everything.
Yeah, that is a nice mix of situations. So that's great. So those are typical situations that would make you have an opportunity to come and see us. And so I think Tammy's going to share with us what's the next step for each one of you.
We do have a question, Meritus, before I say that, from one of the attendees. What would a trust review cost? Is it dependent on total assets or a set fee?
Great question. So there is not a fee. I mean, this is because you're one of our clients, these reviews are free. It's a chance for us to reconnect and really figure out what is going on, right? And so there is no fee. And then what'll happen is after I take a look at all the different things that are going on in your life and your estate plan, then I'll quote you how much it would cost at that time. Can I give you a quote right now? Not really, because it really is dependent on the things that we need to do.
Anyone else have questions? Okay, I'm not seeing anything. What's the next step? Please call us. I will remind everyone our phone number. Bott Associates can be reached at 847-818-9084. We want to hear you. We want to schedule time to meet with you and see what's new. So please reach out to us. You can also email us at info@bottestateplanning.com. We will also reach out to those that have attended today tomorrow. We're going to reach out to you and just hear your thoughts about our webinar and see how we can help. So thank you for joining.
Awesome. Well, thank you, Tammy. Thank you so much for coming to this webinar. I know it's not the funnest topic, but hopefully you learned a little something and that hopefully you take us up on your offer. I'd love to see your smiling face. I miss seeing people. I miss seeing you. So please come out and see us. Have a great day.